Judges in the family court manage heavy caseloads and will actively penalize parties who bring unnecessary litigation before them. The system relies on alternative dispute resolution, or ADR, to settle these disputes out of court. Before you can submit most family applications, your client must attend a Mediation Information and Assessment Meeting, or MIAM. This meeting acts as a mandatory procedural hurdle. In this video, we will walk through the workflow for managing this requirement. First, we will assess if a MIAM applies to your case. Second, we will identify valid exemptions. And third, we will draft a structurally sound referral letter to brief your mediator. Executing this process correctly ensures the court accepts your application on the first attempt. This precision prevents gatekeeping teams from rejecting your client's paperwork and avoids unnecessary judicial criticism. Section 10 of the Children and Families Act 2014 sets the legal baseline. It mandates a MIAM for any person making a relevant family application, such as a private children's matter or a financial remedy order. A client may bypass mediation if there's evidence of domestic abuse, an urgent risk to life or safety, or if social services are already involved regarding the well-being of a child. When an exemption applies, you must secure a Form FM1. An authorized mediator must sign this document to confirm that mediation is officially deemed unsuitable for your specific case. Submitting an application with an exemption, but without a signed Form FM1, usually results in the court rejecting the filing. A judge may also stay the proceedings until the parties attend a mediation assessment. Identifying these exemptions correctly and securing the FM1 protects vulnerable clients from forced contact with an aggressor. It also keeps the legal timeline moving forward without administrative delays. If your client must mediate, you need to set clear expectations. Many clients arrive with the misconception that mediation is a form of couples therapy or an attempt at reconciliation. You should define the roles in the room clearly. While a lawyer acts as an advocate and a judge acts as a decision maker, a family mediator is an impartial negotiator. They focus on the present and future to help parties reach practical agreements. Highlight the tangible benefits of a voluntary agreement. Successful mediation significantly reduces legal costs compared to litigation, and agreements reached voluntarily often result in higher long-term compliance. Proactively resetting these expectations prevents the first session from devolving into an emotional argument about the past. This shifts the client toward a negotiation mindset, increasing the likelihood of a settlement. Once the client is prepared, you must formally instruct the mediator. The referral letter serves as the primary briefing document that ensures the mediator understands the family dynamic before the first meeting. Organize the letter with clear sections for the parties and children. Provide full demographic and contact data, and explicitly note if any party or child has specific needs or disabilities. The Current Position section establishes the relationship timeline. State the exact dates of marriage and separation, and provide the current status of any ongoing divorce or dissolution proceedings. Under Issues of Immediate Concern, isolate the primary flashpoints. Focus on specific urgent disputes, such as the sale of the matrimonial home or holiday contact schedules. Conclude the brief with an Income and Capital section. This provides the mediator with the essential financial data, current property values, outstanding mortgages, and the respective incomes of both parties. A data-rich referral enables the mediator to skip basic fact-finding and move immediately into productive, high-level negotiation. Before sending the letter, clarify the fee arrangements. State the mediator's hourly or session fees and specify whether the client is paying directly or requires a legal aid assessment. Ensure you are utilizing a qualified professional. You can source accredited mediators through regulatory bodies like the Family Mediation Council or the Family Mediators Association. Once the letter is drafted and the mediator is selected, you can finalize the document and officially dispatch the instruction. Establishing clear financial boundaries and utilizing accredited professionals ensures the instruction is handled correctly. This protects your firm from administrative delays and potential liability. We have now completed the workflow, assessing the statutory requirements for the MIAM, managing the client's expectations, and drafting a comprehensive brief for the mediator. Because this approach relies on a clear, standardized structure, it is easily repeatable across your entire family law caseload. A strategic brief provides the mediator with the leverage to settle the case, giving your client the highest probability of a swift, cost-effective outcome.